February 24th, 1803. A court case occurred in a quiet courtroom. The Madison versus Marbury case, destined to alter the balance of power between the executive, legislative, and judicial branches, came to light as one of the most important events of the time period. On John Adams' last day in office, he increased the number of federal judges to ensure that the Federalists would still be a part of the government. These commissions were approved by the Senate, signed by the President, and stamped with the official seal of the government, but the commissions were never given. Thomas Jefferson was sworn into office on March 4, 1801, and told his Secretary of State, James Madison, not to deliver the commissions. William Marbury then petitioned to the Supreme Court to have the government release the document needed to become judge. Madison believed that his position in the executive branch allowed him to withhold the document, but Marbury argued that the Judiciary Act of 1789 gave the court the power to order public officials to do their duty. The midnight appointments of 1801 was the impetus of the Marbury versus Madison case. The midnight appointments were President John Adams' effort to infuse the Federalist influence into the Supreme Court as he exited office. The election of 1800 pitted John Adams, a Federalist, against Thomas Jefferson, a Republican. After Jefferson won the election, Adams appointed as many Federalist judges as he could before his term ended, in an effort that would later be deemed the midnight appointments.
With the loss, I felt that the Federalist Party's power was decreasing. I needed to do something to help our party gain power. Of course, I was disheartened after the loss in the election, but nonetheless, I still needed to make my mark to help the Federalist Party come back to power and reduce the power of the Republicans. Because of this, I appointed many Federalists as judges. It was fair because without it, I feel that the Federalists would have died off very quickly.
Jefferson decided to move the Federalists that had been appointed by Adams in the midnight appointments. These actions were what led to the Marbury versus Madison case in 1803 that would redefine the power of the Supreme Court.
This was a very bold move by Adams, and I had to make sure it was done away with rapidly before it could cause any harm. I felt that I could easily get the Federalists out of office, but it was a much bigger deal than I had expected. I wasn't very interested in this problem as I had more problems to deal with regarding the nation as a whole.
In the February of 1803, the Supreme Court was convening in regards to the Marbury versus Madison case. William Marbury, one of the justices appointed at the end of the Adams presidency, was appealing the fact that he had not yet gotten his commission, the document that gave him the power to be a justice.
I wanted my commission, but James Madison wouldn't give it to me, so I appealed to the Supreme Court and Chief Justice John Marshall.
At the beginning, many people treated the case involving William Marbury and U.S. Secretary of State James Madison frivolously, and many people did not show up. James Madison did not even attend some of the hearings.
I felt it was unnecessary and they would be an easy win. I didn't even need an attorney, really.
Charles Lee, a friend of Chief Justice John Marshall, was hired by William Marbury to argue for him. Lee believed that Marbury was entitled to the position that he was appointed to and that there was a legal remedy, the writ of mandamus.
Mandamus is an order from a quarter court official to a government official that tells said government official to fulfill their assigned duties.
Lee's goal was to prove that the midnight appointments were legal and that the appointed people had rights to their positions. Charles Lee said that President Adams and Secretary of State Marshall had completed the judicial commissions for Marbury and Company, which gave them rights to respective positions. Lee then tried to show that the Supreme Court had the power to issue Madison an order that required him to give commission to the appointed judges. On the other hand, Madison and Jefferson believed that the executive branch held the power of judicial appointment.
My client deserves his commission.
No!
The executive branch was granted the powers to appoint judges. Therefore, I had the power of judicial appointment. How Marbury and his little friends argued was completely foolish.
Thomas Jefferson is a great man that deserved the right to appoint judges that would help with his policies. Federalist judges would have only brought chaos into the government, and that would have plagued his presidency, as he would have been able to accomplish a few things if the judges opposed him, because they were rotten Federalists.
My attorney, Charles Lee, argued that my appointment was legitimate and that I had the right to get my commission. Furthermore, she argued that James Madison had to give me the commission and that the Supreme Court had the power to make it happen. I had been wronged by Madison, and now we were trying to make things right.
In our eyes, we believe that this court case is merely a separation of powers, but what we believe in is that the executive branch should be granted the power of judicial appointment.
Okay, yeah. So like Jefferson here, he's the executive branch right now. He has the power of judicial appointment.
However, my client was granted the commission and it was completely legal and completed by President Adams and by Secretary of State Marshall. So therefore, the Supreme Court has the power to grant my client his commission.
While this seemed like a compelling case, Jefferson and Madison still felt that it was petty and simple.
The executive branch has been granted the power to appoint judges. I have always supported this idea and I will continue to do so in the future.
I believe that the executive branch to be the only determining factor in the case of judicial appointment.
Now it was time for the decision. What would it be, and what would be its effects?
Marbury and Madison are duking it out in the courtroom, displaying their stance and giving reasons as to why their view should be favored. After a long and hard-thought case, Chief Justice John Marshall must make a decision.
This was one of the toughest decisions to make in my entire career. So much was at stake, more than just appointment of justice.
The two options were to offer the writ of mandamus or to deny it. To Marshall, neither option seemed fair.
If I offered the writ, the executive branch could easily decline it, and the court's power would reduce. Furthermore, we could not enforce the writ anyway. If we declined it, the Republican Party would have achieved a significant win.
Marshall felt that Marbury was entitled to receive his commission and felt that it was the court's responsibility to help him as he had been wronged and his rights had been violated. However, he also felt that the writ of mandamus, which would force Madison to give Marbury the commission, was unconstitutional. While this was determined, the constitutionality of the Judiciary Act of 1789 came into question. As the court examined its own powers and rights, it determined that the section in the Judiciary Act of 1789 in which it stated that the court could issue the writ of mandamus was unconstitutional. Marshall and the court felt that the Congress, which had issued the act, did not have the power to control the court as it was unconstitutional. Therefore, it was the decision of the court that
I declare that the issuance of the writs of mandamus is not in the power of the court to be issued. Therefore, the Judicial Act of 1789 is unconstitutional. This conclusion drastically changed the governmental structure. Because of the case, judicial review was established. Judicial review stated that the Supreme Court decided whether Congress violates the Constitution. This gave the court an abundance of power.
By utilizing a method coined as a tour de force, Marshall was able to effectively establish the role of the judicial branch. In his statement, he attacked the actions of Jefferson's presidency, claiming that Jefferson had attempted to undermine the laws established by the Constitution. This action was largely due to Marshall's belief that the decisions of the court could possibly be ignored by the executive branch altogether. However, if they sided with Jefferson, it would seem that the judicial branch was simply a subordinate to the executive.
It was declared that the Congress's actions had infringed on the rights of Marbury. Despite this, the ultimate decision did not favor Marbury or Jefferson completely. Marshall declared that issuing a writ of mandamus would be unconstitutional, thereby voiding the rights the judicial branch received from the Judiciary Act of 1789. The act itself was later deemed unconstitutional because the Supreme Court was only giving appellate jurisdiction according to the Constitution rather than original jurisdiction stated by the Judiciary Act of 1789.
This maintained the fact the judicial branch was an effective part of the checks and balances system in charge of interpreting the Constitution and evaluating laws to see if they followed the principle of the Constitution.
I feel that this was a very poor decision because now I didn't get my commission.
My party and I are very disappointed because the Supreme Court did not force the executive branch to issue the commissions that I assigned during the midnight appointments.
As of this case, I am not in favor of this decision because now the judicial branch has the power to manipulate the Constitution.
Like Jefferson, my party and I are also very disappointed at the results of this case
because it allows the court and the Supreme Court to get more power over the executive branch.
Well, bam, let's go. Okay. Done.